Welcome to Undoing I Do with Stephanie Ade. I'm Stephanie Hunnell, the owner of the Hunnell Law Group in Asbury Park, New Jersey, and your co-host for this evening.
And I am Adela LaSherilyn Dow, the owner of the law offices of Adela LaSherilyn Dow in Staten Island, New York. Hello, everyone.
How's
Thanks for
everyone doing tonight?
I hope everyone's doing great. I hope you start giving us some questions and engaging with us. Check out our YouTube page, where if you can't see this whole thing on Facebook right now, you can look at it later on Facebook or check it out again on YouTube. Don't forget to ask us your questions if you have any. Even if you're not watching live right now, you can always put questions in and we will try to get back to you. You can put criticisms in too. We'll read those.
We got a nice little emoji last time.
Yes, it was a emoji. Anybody from Brooklyn and the tri-state area, maybe not Connecticut, I don't know, knows what that means. We welcome it.
Yeah, we welcome it. By the way, it makes the show more interesting when we have some feedback, whether it's good or bad. At least we can learn from it.
That is correct. And today we are going to be talking about how to hire a divorce lawyer.
Oh.
It is.
I think I just lost you for a second.
Oh, you did? I see you.
Okay. Sorry about that, guys.
So tonight we're going to be talking about how to hire a divorce lawyer.
Yeah. We talked about something similar last year. And, I think I was looking at this again and my opinions changed a little bit. I think one of the number one things when looking for a divorce lawyer right now since COVID, I really think that you need to hire somebody, aside from having, family law and divorce experience, these attorneys need tech experience, or at least not to be afraid of it. I have so many cases right now with several attorneys that just don't understand tech. They didn't want to open a Google Drive with documents. They're afraid to send anything. They want paper copies of things. And the court's not even getting paper copies of things. So it takes a lot longer for these cases to go through.
Yeah, I have to agree with you. So I think that is twofold, because in looking for an attorney, it's a certain type of client who's going to be looking for somebody who's tech savvy. And it's usually a client who themselves is tech savvy, but you have to be careful. If you are not tech savvy and you want an attorney who does things the old school way, you might be causing a problem for yourself, because the courts are no longer doing things the old school way. And so, whereas it might be comfortable for you, it's probably not going to be profitable for you in the long run, because if your attorney can't upload and download documents to JEDS, which is another story, JEDS is something else, or in New York, NYSCEF, that's a bit of a problem. So you want to make sure that you hire somebody who has a team that is tech savvy and that can pull you along with learning how to be tech savvy so that you can help them help you.
Absolutely, because we have to upload all of our evidence, whether it's for motions, conferences, trials, all of our evidence, all of the documents that we submit to the court have to be electronically filed now. And if you don't have an attorney that understands a PDF, if you don't understand it, that's one thing, because if you have an attorney that can assist you, like you said, have a team at least that can assist you, you can get everything filed correctly. But I think it's a game changer right now if you don't have that. I had a judge yelling at an attorney last week because he didn't want to accept the electronic discovery. And the judge was like, click the button. You have to. It's in your possession. You can't say you don't have discovery just because you don't want to click the link. I ended up having to send it on a thumb drive.
Look, yeah. I had somebody last year or the year before, because we were in court then, so it must have been 2019. And this woman, I had given her a thumb drive and she did not want, she was like, Judge, I shouldn't have to look at the thumb drive. So now imagine that was in 2019 and you won't take a thumb drive. Doing things on paper costs more money.
Mhm.
And it takes more time. You're sending things in the mail. You're using FedEx. You're copying. So you're going to get $1,000 copy cost from your attorney, and wonder how the heck they spent all that money. It's because they have their secretary or somebody sitting there for hours copying your stuff, and then they're putting it in FedEx, and then really, go with embrace the change. And I would agree that is a number one consideration. Go with
Yeah,
somebody who, even if they aren't tech savvy themselves, their team is.
exactly. And again, it saves you a lot of money, not just with copy costs and that kind of stuff, but an order came down just today in New Jersey regarding whether or not they're going to keep virtual proceedings in the
Yes.
state of New Jersey. And it gave the courts some discretion regarding what they can and hold in person and what they don't have to hold in person. They gave a presumption regarding the things that should be held virtually. And over the last year and a half or so, with all of the virtual proceedings, my clients have saved a substantial amount of money because we don't have to go to court on a 20-minute case management conference and sit there for 3 hours and bill you for 3 hours and bill you for the time in the car.
That's right.
We get to sit in front of the computer. We literally show up for our half an hour. We have our 15-minute conference, and the courts have pretty much timed it very well, other than a few judges. But and you're only paying for that time.
Yeah, that is a huge benefit. That is a huge benefit that people who are just starting their cases now may not realize. It used to be, if you're just starting a divorce case, and you're like, well, this is the only way I've known. Well, it used to be that Stephanie and I would get to court at 8:30 in the morning. Your case may be just a general calendar call. The judge could have 20 other cases on, and we are still sitting there at 1 p.m. waiting for the judge and his staff or her staff to get back from lunch to hear your case. So yes, that is a major benefit.
Yep. I mean, I've sat there the entire day sometimes for a 20-minute conference because an order to show cause comes in or some kind of emergent application comes in, or they call a judge meeting that all the judges have to go and they say, sorry, come back at 2:30. We're not going to take any more cases. Yep, exactly. And it does happen, but we're sitting there waiting and you're being billed for all of that time.
You are paying. And I would sometimes sit there and have something else to do, but sometimes you didn't bring anything and now you're just because you thought it was going to be in and out. The other thing that I have to suggest, because I'm involved in this right now, is to not hire an attorney who just wants to litigate for the sport of litigating. I am in a case right now where my client is winning orders, and the other side, anytime my client wins anything, runs into the appellate division in order to smack down the judge. Now, we are a few weeks away from trial. This person has trial going on in January. We have a pre-trial conference at the end of this month, and this person is still coming out with appeals. Because they can. Not only is the person coming out with an appeal, now they're reaching way back into the past for a car accident case. My client is accused of hitting the spouse. I don't think that my client meant to hit the spouse, but of hitting the spouse with the car from the driveway. And now that's a filing. Why? Probably because the person doesn't want to give my client his or her share of the house. Come on. Stop. Don't hire somebody because they are going to be. Somebody called me somebody the other day called me a pit bull. And I like to litigate. I like to litigate, but not for no purpose. Don't hire somebody that's just going to be like, we're gonna get them just to get them. You're wasting your time. You're wasting your money. This person is potentially spending tens of thousands of dollars that they could have just either given to my client, which I'd rather have the money go to my client than have it go to me, quite frankly. And or they could have saved the money for their kid. Why are you? Oh my goodness! Just don't.
On that same point, I just received a motion to be relieved from another end of the divorce case. So the adversary decided to file a motion to be relieved. And when I'm reading the motion, they no longer want to represent their client. Their client had already paid them $65,000. We are just at the ESP stage. So we haven't even gone,
Wow.
we have not even gone to economic mediation yet. And so I'm looking at this bill, and this particular attorney was very litigious, fought us on everything. I sent over proposals. They rejected proposals, like very reasonable things, temporary relief, would not agree to it. It ended up costing his client a lot of money. And now I could read between the lines, the client doesn't want to pay. So the attorney no longer wants to represent the client. It does you a disservice for yourself to hire somebody like that. Even if you think that you want to get back at your spouse and you want to fight everything, if you hire an attorney that's going to just fight for everything without giving you guidance on what you should and should not fight for, you're going to end up like that, spending too much money.
Absolutely. You absolutely will. And then you will not be a happy camper at the end of the day. That person,
He's not
okay,
happy.
that person is upset because now they done spent 65 G. I think of life in terms of cars. So that's probably like a 2018 BMW 5 Series or something that's completely souped up. This is how I think of things. And so, or maybe a Range Rover Velar or something like that.
Yeah,
That's how I think of things. It's a whole car and a nice one. And now they want to talk to you.
It's also a couple years of your kid's college.
Yeah. I mean, if they're going, yeah, it would be. It would be with after scholarships if they're going to a private school.
Yeah.
This is a lot of money.
And really, less than half of that should have been paid, because there was at least 2 separate motion practice rounds that we did not need at all.
Yeah, so just to let people know, ESP is generally in New Jersey your second court appearance if you haven't had any additional motion practice that causes you to go into court prior to that. And so to think about, you've not even gotten to your second court appearance and you've spent $65,000. No. Yeah.
Right.
Don't let it happen.
Yeah. And just so also, an ESP stands for Early Settlement Panel. And that's why it's a second court appearance. They try to give you an early opportunity to be able to resolve your case. And, a lot of times discovery isn't even complete by then.
That's right.
So yeah, the cost is astronomical in this case.
That's craziness. So what's your next suggestion for people?
So my next suggestion was going to be personality. I think that if you are very outgoing and your attorney doesn't like to talk, I don't think that you have to be like best friends or anything like that. But I really do think when you're meeting with an attorney, you need to have some level of comfort that they're understanding you, they're empathetic to what you have to say, they're actually listening to what you have to say, and that when you communicate with them, you have kind of a wavelength of a personality. I mean, you're going to tell your divorce attorney very personal things. Your divorce attorney is going to have to tell you very personal things and to tell you your business, how you need to arrange your life after a divorce and what you need to do to, settle economic issues, child custody issues. And sometimes we have to call you out on some of your antics.
Yes.
Yeah. So you want to have somebody that you at least mesh with from a personality perspective, I think.
I agree with you. People often say, and I've said this before, hire the nastiest lawyer that you can find, somebody that even you don't know that you like. I completely disagree. You're going to be spending a lot of time dealing with this person, dealing with their staff, dealing with we no longer go to court really anymore, so you don't have to sit next to them. But I don't want to give my money to somebody I don't like or that I can't get along with. Again, your attorney is not your best friend. Don't hire an attorney simply because they start to sing Kumbaya with you and hold your hand. That's what your therapist is for. That is not what an attorney is for. So, but that doesn't mean you have to hire somebody who's cold-hearted and has no bedside manner, for lack of a better term.
Yeah. Yeah, same. And again, just like you said with the kumbaya, if you leave your office and you're like, yes, this is amazing. I'm going to have like the best divorce ever. I'm going to get everything I want. That's a red flag.
Don't hire that attorney because you're not going to get everything you want. I want to get you everything you want. But I also know how unrealistic that is. You don't get everything you want in life.
Mm-hmm.
It's just not the way it works. And if your attorney is telling you that you're about to get your spouse's shoes, their pants, the house, you're about to get their hopes, their dreams, the kittens that they're going to have in 3 years, please walk away from that person because it's not true. They are out here selling you a pipe dream so that they can get the retainer.
Mm-hmm. Yep.
So I talked
What's
to a client, a potential client last week, and he said, "So basically, you're just like not telling me what I want to hear right now." And I said, "Right, that's why you called me because I'm not going to tell you what you want to hear. I'm going to tell you what's real. You want to plan your exit. Here's what you need to do to plan your exit
Mhm.
because if you don't do this, your exit may be a little bit bumpy, and I got to tell you that. It's my job."
Yep. Yeah, I tend to ask my clients or prospective clients what their goals are. And then I list what their goals are. And I actually do keep this in mind kind of at the end. Like I could go back to it and say, remember when you said these were your goals? Now you switched and there's something else. So that's an aside. But I ask for their goals because I want to know how realistic they are. And I want to be able to tell them, here's where we can go with that. If you really want this bigger piece of this, you're going to have to give up something else along the way. Because that's just the way divorce is in this context with equitable distribution. It tends to be 50-50, even though it's, not 50-50 by statute, but that's where courts tend to go for most long-term divorces.
Right. The longer you're married, yeah, the more fair the court thinks that is to
Mm-hmm.
do. The other thing that you have to do is to ask the person about their billing practices. Okay. We were just talking about a situation where somebody ran up a $65,000 bill in a matter of, I'm sure it was only a few months. I'm sure that because of the way you were emphasizing it, it's not the situation where you all were trying to negotiate this case for a year prior to it being filed. And even a year prior is $65,000 is still not it. Okay. But I would ask them, how do you bill? If they say, oh, I pull up this, Word document and I just type in what I've done, once again, don't do it. Because if people don't have good billing practices, they probably also don't have good organizational practices with regards to how your case is going to be presented. But they are certainly more likely to make mistakes about what they're billing, how frequent they're billing. Okay, if you ask them how often will I get billed, and they say, oh well, we'll bill you when we run out of your retainer. No, that's not the way this gets done. Okay, our
Yeah.
ethics rules require you to be billed at least every 60 days.
Mhm. Yeah,
So
the general practice, I think, for New Jersey, at least the attorneys that I've talked to, that's between 30 and 60 days, you're going to get a bill. If it's a small amount of time that's been spent, you might get it the 60-day mark or something. But
right.
you want to know our rules require regular billing, and you need to articulate everything that's being done. A few years back, I helped a friend go over some of his billing, and he showed me what his attorney sent him, and there were huge blocks of time and just ramblings of what was done, and then like 5 hours. So it was everything that was done in a day, and then an allotment of time. Nothing was articulated per task, which really is what you should be looking for. I'm kind of crazy about it because I've had to go to FIAR before, and I know that when you go and the board is looking at what you're billing, they want to know each item. So if you spent 5 hours on something, they want to know, was it an hour on a brief? Was it 0.5 on a letter? They want to know all of that stuff. And frankly, as a client, so do you. you don't want to think that they're just randomly trying to meet their billable hours for the month or the week and using you to do that.
On your case, right? On your dime.
Right.
Right. And tell the people what fee arb is.
So fee arbitration is in New Jersey, something that a client can elect if they disagree with the bills that were charged. So they can go into and request fee arbitration, and you go, depending on the size of the bill, you'll either go before 2 or 3 panelists, and I think you get one lay person
Right.
if it's over like $20,000 or something. I forget the
Yeah, our
threshold.
rules are very similar in New York. And so you know, when you get your bill, open up your bill. Look at your bill, read your bill. People make mistakes. Don't wait 6, 7, 8 months and then start going over your bills because you're like, wait, I just realized that I just looked at my check register and I have given this firm $30,000. Let me figure out what I paid. No,
Right.
do that before. Do that beforehand. And then, you know, a lot of people think that it's important to know where somebody went to law school. It's important to know that they went to law school. It is not necessarily important to know where they went to law school, because you're assuming that you can judge whether a law school is good or bad, whether it preps you or not, based upon the name. So that if somebody went to an upper tier school, they went to Harvard or they went to Yale Law, you're automatically thinking, oh, they're going to be the better lawyer for me. That is not necessarily so. And I got to tell you that usually once somebody asks me that, I know that they're not on the right track in terms of what they should be looking for in a lawyer.
Yeah.
What's more important is whether they have the experience that you need in order to get you through this time in your life.
Exactly. I mean, I think it's a fair question to ask how long the person has been out of law school.
Absolutely.
If they've gone to an upper tier school, perhaps they have no work experience. I mean, I'm just throwing out generalities, but you know, and then somebody that might have gone to a lower tier school but worked at nights and worked in a law firm and was a paralegal and has that experience, who is out a year, will have a different experience than a first year attorney who's never had experience during law school. But in any case, law school really doesn't prepare you for the meat and bones of representing a client. It teaches you the law. We read a lot of very dry textbooks. We have to memorize a lot of rules. But from a practical standpoint, they're not teaching us how to, I don't know, navigate a client through a divorce litigation and make sure that we're strategizing and completing case information statements and, you know, that kind of stuff.
Know that no, law school does not teach you any of that. It also does not teach you how to necessarily run a law firm properly either.
Oh, yes, that's not. I don't even think they think attorneys have to run law firms the way they like law school goes.
It's amazing. So no, yeah, it's important to know whether the person has the experience by virtue of asking you that. But I will tell you that I started my law practice when I only had 3 years in. And I thought I was badass then. So you know, it's one thing to think that you're badass and be badass. You don't have to necessarily have been out of law school for 10 years in order to properly practice in a case, because you know, if somebody has less years, you might want to say to them, okay, so what have you been doing during those years? What is who are your mentors? Where did you work? That type of thing. Because if that person worked for a large matrimonial firm, for instance, and they were an associate there for 2-3 years, and they were on this committee and that committee, perhaps they're okay with, perhaps they're the right fit, you know, to lead you through. But the other thing that you want to think about too, I think, is, does this attorney have enough experience in the court where your case is going to be proceeding?
Yes, I agree. I have turned down cases, a little less so now because of everything is virtual. But if I'm not in that county, I tend to not take cases in that county. I'm very familiar with Monmouth, Ocean, Middlesex counties, which is like the counties right where my law firm is. And because I know the judges, I know the staff, I know the procedures, I know how they prefer things to be filed. I know whether they want letters uploaded and emailed, or I do still want, some judges want them uploaded and mailed.
Yep.
There's
Yep.
certain things, and we know those things because we've practiced in that county regularly. If I had to go up to like, Passaic or something, I don't take a lot of cases there. So I'm a little bit out of experience when it comes to who the judges are. And I have a lot of experience, but I don't know who the judges are. I'm not familiar with the law clerks. I can't call them on the phone and they don't recognize my name. So there's some of that.
Yeah, that's absolutely correct. And, knowing your judge means a lot. Knowing your judge means a lot. It's probably almost more important than knowing the law. Right? Because you know what's going to be your judge's trigger points. You know what they're going to value a lot more, right? So, when it's a judge that you don't know, maybe you're thinking, oh, I got to write a whole memo of law, I got to do all of this stuff, and your client's paying for that. But if you know it's this judge who's never going to read that stuff anyway, all right, I'm not going to do that. Everything that I'm going to do here is going to be on oral argument. Okay,
Yep.
and I'm going to win the case on oral argument because I'm going to cite to this or that because I know that judge cites to that all the time in their documents, right? That's the type of lawyer that you want to hire. You want to hire somebody who can say, yeah, judge, this is more like blah 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 blah. When
Mhm.
when the attorney starts talking like that, starts speaking like that, you probably have the right one.
Yeah, I agree. I totally agree. I'm just thinking of one judge in particular, um, who you just had to have the last word during argument because then he's like paying attention. He would tend to nod off sometimes. um, and so, yeah, I would never give a legal brief to him because it would be a waste of time and resources because I know he wants to hear oral argument.
Mm-hmm.
And he would peruse the papers, but he wouldn't necessarily know all of the facts. So we have to point them out. And there's other judges where I don't even have to argue what's in my papers because I say, I know that judge read everything. The judge will recite it. And I can say, if you have any questions, I want to highlight 2 points, but if you have any questions, let me know. And the judge appreciates that because we're not wasting the court's time
That's right.
regurgitating everything that's in the certification when other judges really need us to do that.
Because they haven't done their homework.
Yep. Yep.
Do you need to hire if the attorney charges a consultation fee? Should that be a turnoff for potential clients? My answer is that it
I
shouldn't be, but
imagine
I want to hear your answer.
No, I imagine your answer should be no. My answer is no. I actually am. I shouldn't say I'm more concerned, but if you don't charge a consultation fee, um, I I'm trying to be like polite about it because I think that maybe I
For
think
any
that
of our
maybe
colleagues out there who don't charge a consultation fee, this is not about you. It's not.
No, I do think I think most of our colleagues do charge something. They might waive it, they might have another kind of a structure, but I do think they charge something. It kind of weeds out clients and want to make sure that you're prepared to invest. I also think sometimes there's attorneys, and that's not everybody, that they don't charge a consultation fee because they want to get as many people in the door as they can, just in order to get people in the door. So that's my concern about not charging a consultation fee. I know
Right.
some people absolutely aren't doing that. They're not charging a consultation fee, but they're not just trying to bring everybody in the door, but they want to give a benefit to the prospective clients.
Yeah, yeah. Charging a consultation fee doesn't mean that the person is only fixated on money. I'm going to tell you that when you go to school and you are doing those student loans or you're running a practice and this, that, and the other, you want to make sure that you spend your time very wisely. But here's the bottom line. Your attorney is working even if you haven't hired them, when they are talking to you about a case, they're working. And so most people want to get paid for doing work and they charge a consultation fee. But the other reason why that people don't think about is that when the attorney speaks to you, they are now precluded from representing anyone whose interests are different from yours or in direct conflict with your interests. And so they have essentially taken themselves out of the running for being hired by your adversary, or, or anyone else who you would have a conflict with, really. And so that's a cost that the attorney is incurring that is a silent cost to you.
Right.
So when the attorney is charging a consultation fee, it's generally because they have thought about the cost to them for sitting down with you, not only for the time, but also probably for analyzing your case. I mean, I think that, I think Stephanie is like this too. I'm an attorney who does give legal advice during strategy sessions. Um, I haven't yet caught on to the not giving legal advice, and I know a lot of our colleagues don't give legal advice during strategy sessions. But I think that most people want to hear from an attorney whether they can really help them, and be satisfied and confident that the person can help them, as opposed to having somebody say, "Oh yeah, Attorney Dow can definitely help you with that. Send us your $3,000 worth of whatever it is,
And
and
then
we'll help
he'll tell
you
you. Exactly. With regard to the fee also, I mean, you have a very busy practice. I have a busy practice. And if I didn't charge a consultation fee, I would spend several hours a week talking to people that weren't going to hire me anyway. Hi, Nicole.
Hey, Nicole. Hi,
Um,
Lynn.
so I think that also frees up the attorney to know you're slotting your time, you're getting paid for your time, and you're giving true focus to your, 1 hour or 45-minute consultation, whatever it is, or strategy session. I do strategy
Mhm,
sessions like you do
mhm.
now.
So do I. Yeah. So these are some of the considerations that, you need to make when hiring somebody. I think that the most important consideration, though, is making sure that you feel comfortable and you feel like this person is not selling you snake oil.
Mhm.
If you feel like the person is selling you snake oil, or something about the person just doesn't jive right with you, don't hire that person.
Mhm. Trust your gut.
Trust your gut, because we're going to trust our gut in terms of deciding whether you are to be our client. So trust your gut. Don't
And
just give your money over to somebody because they did your girlfriend Sally Sue's divorce, and she thinks that they did right by by her.
yeah, and don't forget, we're also interviewing you. So
Right.
for the most part, we want to make sure we're a good fit for you and you're a good fit for us.
Exactly. Exactly. We hope that this show has given you some benefit, and that you'll pair it with the first show that we did, about it's a similar issue about, how to interview attorneys and so on and so forth. We hope that you pair it with that, and that it gives you the resources that you need to make the right decision for hiring your divorce lawyer.
Have a good night. See you next
Good
week.
night.
2 weeks.